Hello, good afternoon. Thank you for joining the webinar presentation today on the new salary level test and changes to the FLSA. Our presentation, the 2016 DOL overtime rule changes, what it means for you, is about to start. My name is Ellen Adams. I'm a shareholder at GableGotwals in our Oklahoma City office. And joining me in this presentation is Erin Daly, who is a shareholder here in our Tulsa office at Gable & Gotwals. As we work through the webinar, if you have any trouble hearing, there's a button on the bottom that is a raise your hand button, so please alert us if you're having any technical difficulties. There's also a button on the screen which will allow you to type in any questions, and as you type those in, we will do our best to find a way to incorporate our answer into the program. Thank you so much for joining us. I'm going to turn this over to Ms. Daly.
Good afternoon. So this might capture the way a lot of us were feeling when the DOL first announced it was considering a rule change, and we heard what that rule change might look like. And then, of course, it has come out, and it was almost as bad as we thought it was going to be, not quite. Instead of $920 salary rule, it's $913. And I know this was a lot of our first reaction, but we are here to tell you it's okay. We can help you. We can work through this if we kind of take it step by step. So, of course, first question is what happened? As you all know, the new rule increased the salary level test for exemptions under the FLSA, and it's set to go into effect on December 1st, 2016, which doesn't give HR and managers a whole lot of time to get ready. There are some efforts in Congress to stop the rule, to put a hold on it while Congress considers its impact and that sort of thing, but in order for that to be effective, it would have to be signed by President Obama, and there doesn't seem to be a whole lot of hope that that is likely to happen while he remains in office. So I think we have to go forward expecting that these changes are in fact going to take effect on December 1st. As you all know by now, the salary rate for classification of exempt employees is going to go up from about $455 per week, which if you work a full year comes out to about $23,600 annually. It's going to go up to $913 per week, which comes out to about $47,500 per year. So a huge increase pretty much overnight as far as the salary threshold goes. And of course what this is going to do is result in a lot of employees who are currently classified as exempt to now be deemed non-exempt unless there's a change in their salary. You know, a lot of what we're looking at and seeing and hearing concerns about are folks who are under, in particular, the administrative exemption or the executive exemption, who are in that $30,000 to $40,000 salary range. I think that's the group that's really going to be impacted by this the most. That's going to also result in the biggest potential financial impact to businesses. Just breaking it down a little bit, the salary requirement is per week. So we talk a lot about the annual amount, the $47,500 roughly $500, but really they're looking at the $913 per week from the DOL's perspective. So if you operate, 8 months per year, you have to make sure the salary threshold is met per each week the exempt employee works. Now, of course, that's not true for people like, for example, in the school where they're paid for 12 months for 9 or 10 months of work. In those circumstances, DOL will let you look at the weeks they were actually working to see if the salary threshold is met versus, making that apply to each week during the 12-month period. But if you're operating and paying folks only for 8 months, you've got to make sure you're paying them the minimum salary for those 8 months. Really, the scope of discussion about workers who are temporary or who only work seasonally is beyond the scope of what we're addressing here today. I have provided you with a link that provides some more detailed information about how to handle seasonal type employees. Part-timers, this is another area where there is going to be a pretty significant impact, I would expect. This new rule doesn't make any exception for part-time workers. so to be exempt, the employee has to meet the weekly salary threshold, whether they're working 25 hours per week or 40. And so that and the flex time area, I think, are two areas where this is really going to have a significant impact. And you're probably going to see a lot of part-time employees have to go to a non-exempt status. And I'm sure you're also aware that the new rule provides that the salary threshold is going to be, quote, automatically updated every 3 years. So while they haven't promised that that will result in an increase, that is definitely what the expectation is based on cost of living standards, as they pretty much universally go up every 3 years, every year. That's what we're expecting. The original rule was going to do that every year, so that was a bit of a break for especially the HR folks among you. That a lot of the feedback that the DOL got was there is no way we can, on an annual basis, have to reevaluate and readjust salaries within our organization on this basis. And so the DOL decided that they would be kind and only do this to you every 3 years instead of every year. So I guess that's one piece of what we might call the good news about this. Other, I guess, what we could categorize as good news as far as the rule change goes is that employers are allowed to count non-discretionary bonuses, incentives, and commissions toward up to 10% of the required salary level, as long as those are paid on a quarterly or more frequent basis. So first of all, they have to be non-discretionary, right? This can't be your end-of-the-year Christmas bonus. Maybe you get it, maybe you don't. Maybe it's $1,000, maybe it's $800, maybe it's $1,500, you know, just depending on what kind of year we had. It's not that kind of bonus. It's the incentive bonuses, you know, if we produce 600 widgets in the next month, everybody's going to get $100 added to their paycheck. Those type of bonuses that are predetermined, that are used as incentives for workers to, you know, work more efficiently or achieve a certain production goal, those can be included toward up to 10% of that required salary level. Again, the discretionary bonuses are those for which the decision to award the bonus is at the employer's sole discretion, and it's not in accord with a pre-announced standard. So the typical example is, you know, the end-of-the-year bonus or the Christmas bonus. That kind of depends on a look back at how things happened versus a looking forward. It's decided if X happens, then Y will be awarded. The quarter can be determined by you. So again, hooray for DOL. They've given you a little bit of discretion here. It doesn't have to be based on the calendar year. Again, though, you have to decide that ahead of time how you're going to structure your quarters. And if you operate on a different fiscal calendar, it's fine for you to follow that as far as determining whether these bonuses are paid quarterly, if you're using that to get yourself up to where you need to be under the salary rule. So why are they doing this to us? I know that's another question that a lot of us have had. And you know, it really isn't all bad. They're not out to get employers. That's not what their focus is. I know that sometimes the impact of these can feel that way, and it can feel like it's a little bit tone deaf as far as what business needs are. There are some valid reasons that this rule needed to be looked at. In 2014, President Obama directed the DOL to re-examine the overtime regulations. And I'm sure you've heard in speeches, he talks a lot about a fair wage for a fair day's work, you know, wanting to make sure that especially middle-class Americans are being compensated fairly for their time. In regard to this particular exemption and the salary level test, it was set in the 1970s, and it has not been increased since that time. So at the time that it was set, $23,660 was really about 38%, in the upper 38th percentile of middle-class salaries at the time, and that's what the government was going for. Well, now in 2015, that level is below the poverty line for a family of 4. So the original intention of the salary test was to make sure essentially that you're paying people a solid middle-class salary. They can make a decent living with that money without the benefit of overtime pay. And the DOL decided that that goal was not being met at the current level. So most people agree that some kind of increase, you know, was not beyond the pale. Even if you didn't think it was necessary or appropriate, okay, we can live with that. The problem is that they almost doubled, you know, their requirement overnight. And that's what Congress has really expressed a lot of concern about. And that's what they're having hearings on, you know, and trying to take some action. And there's actually, it appears, some bipartisan support for that in the Senate. But again, there's a big question about whether President Obama would actually take the step to put the brakes on this. And we're not expecting that to happen based on the sources that I have seen. You know, some of the concerns expressed are regional cost of living differences. You know, $23,000 in California is not the same as $23,000 in Oklahoma. What DOL has said is they looked at the lower sector of the economy nationwide when they made the decision. That's been cold comfort for a lot of businesses, considering the level of the increase that's happened. Another big concern is the impact this will have on nonprofits. And I don't know if any of you listening today are involved in that sector, but you know, the impact that this is likely to have on nonprofits is potentially staggering. And that's something else that Congress is having specific hearings on. And so I don't know what will come of that, but as we look at it now, it looks like a lot of nonprofit jobs are probably going to have to go to an hourly level because they simply can't afford to pay people $48,000 per year in that sector. So that's kind of what we're faced with right now. And before we get into the specifics of the rule change, I want to shift gears a little bit and turn it over to Ellen. And she's going to talk about some of the rules of the road and kind of set a framework for the rest of our discussion.
And before we get to that, I guess we are receiving some feedback that some folks might be having trouble, or this could be just isolated to one person. So if you are having trouble with the audio, please go ahead and click the button that is a thumbs up on your screen so we can evaluate what we might need to do to respond to that. Okay, so the essential rules of the road for the Fair Labor Standards Act. There's a few essential elements of compliance. So what does the FLSA require? Well, in short, that requires payment of a minimum wage and payment of overtime when an employee works over 40 hours in a work week. So as Aaron has talked about, a work week can be employer defined, and overtime, this is a common misconception, but overtime is not just time and a half from what an hourly wage might be. When we talk about overtime, what we're talking about is calculating based on a regular rate of pay. And that is a defined term under the FLSA, and we need to be cognizant of what is encompassed in the regular rate of pay whenever we are doing a proper calculation of overtime for employees who are non-exempt. And that's the other factor. So if you're exempt from the FLSA requirements, that means that overtime is not required. So being exempt, in order to qualify, you have to meet essentially three different factors. You have to be salary-based pay. So that really is a question of whether you're on a salary, meaning that you're not hourly or that your pay is otherwise adjusted based on the quality or quantity of your work. It also means that you have to meet the salary level test, and that is the significant change that we're addressing today that the DOL has ruled on and that will be effective in December, and that's how much you're paid. And then the third factor is the duties test, which is how you are classified. And an essential element of compliance is to make sure that you are properly classifying your employees, to make sure that you have correctly classified them as non-exempt. Because if they are not exempt from the FLSA, that's where you do have to pay attention to minimum wage and overtime. There are certain exceptions that apply. We've outlined some of those. For example, full-time students, student learners, apprentices, and also entities that are not engaged in commerce, such as purely religious organizations, may be exempt. So those are the essential elements of compliance with the FLSA. So as we mentioned, classification is key for compliance. An FLSA exemption is applied on an employee-by-employee basis, not to a particular job title. So just because you have two employees who are both doing the same, or categorized as being under the same job, one could be exempt and another non-exempt based upon their level of compensation. Also, what's very important is that job title does not dictate the duties necessarily of the job. So although you might fit within a job title that sounds like many of the classifications, that doesn't necessarily mean that what you're doing falls within the primary duties tests of the particular classification. Of import, especially around this time, or any time where we have a shift in our economy where there might be hiring freezes for an organization, it's particularly important to recognize how an employee's duties may shift during that time period. So for instance, if you have a hiring freeze and someone who formerly had job X now has job XY, job Z, and job A all together. And you really have to pay attention to what all of those jobs require that employee to actually do, because it is what the employee actually does that matters for whether or not they can be classified as exempt. Employee classification. The key here is to make sure you get it right. There are 6 primary exemptions: executive, administrative. Administrative is very tricky, and we will get to that in the slides to come. Professional, there's some exceptions there. Computer, outside sales, and highly compensated employees. All of these, but the outside sales, must meet the salary level test. So let me just, before we get into the administrative and some of these other exemptions, run down the list here, which we won't cover in much greater detail. The executive exemption is for those employees whose primary duty is managing the enterprise or a customarily recognized department or subdivision of the enterprise. An executive has to be someone who regularly directs the work of at least 2 other full-time employees. So that's a very specific type of classification that your executives will qualify as being exempt if they meet the new salary level test. Computer. This is limited to computer systems analysts, computer programmers, software engineers, and other similarly skilled workers in the computer field. So their primary job duties need to be application of systems analysis techniques and procedures to determine hardware, software, or system functional specifications. So again, if you have an employee in your organization who has those primary duties and also meets the new salary level test, then they can qualify for the exemption. Outside sales. This is a unique one because it's not subject to the salary test. However, it is a specific exemption that you have to meet the duties requirement to qualify for. And the primary duty there is making sales, and that's defined by the FLSA, or obtaining orders or contracts for services for the use of facilities for which a consideration will be paid by the client or customer. And the employee must be customarily and regularly engaged away from the employer's place or places of business. And that's significant, especially how the FLSA defines where the employer's place or places of business are located. So if you regularly have someone who has a home office, be very cautious about whether that under the FLSA is in fact the employer's place or places of business for an outside salesperson to meet the exemption. We have received a question, which is, can you pay a non-exempt person a salary that includes overtime, such as paying a salary for 42 hours of work?
So I'll just jump in. You can pay non-exempt employees a salary, but you have to ensure that you are separately calculating overtime at 1.5 times their regular rate of pay. So I would not advise just building in, okay, your work week is 42 hours a week and this is your salary. It needs to be your standard work week is 40 hours a week, and on a weekly basis, you need to be looking at how many hours were worked in that week and calculating the excess amount. I know it would be easier to do it the other way, but if DOL ever got involved, they would want documentation showing that you had done that calculation. And kind of doing it almost preemptively or prospectively, I don't think is likely to meet their requirements and could get you into trouble potentially.
Yeah, an employee is not permitted to agree to any type of special arrangement around these rules of the FLSA. So the employer would not be able to rely on an employee's agreement to accept a certain salary for 42 hours of work on a weekly basis to avoid complying with the overtime requirements of the FLSA. Okay. So we'll turn now to this administrative employees exemption, and this is the one that we have remarked is a bit tricky. And the reason that it's a bit tricky is that there are a lot of words that the Department of Labor has placed guidance around. So at quick and first blush, you might think that lots of employees might qualify for this particular exemption, but the way that the Department of Labor and the courts have construed this exemption is very narrowly and strictly. So certainly the salary level test will impact many people who may have been classified perhaps improperly under the way the DOL has interpreted this, but it should narrow further the scope for employers to really understand this particular classification. So when it says the primary duty must include the exercise of discretion and independent judgment with respect to matters of significance, and the primary duty must be the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. There are several key words in there, one of which is directly related to. So this is a primary duty test. It has to be the principal, main, major, or most important duty the employee performs, and it has to be directly related to the management or general business operations of the employer or the employer's customer. So for instance, an HR professional might be performing work that is directly related to the management or general business operations. So that's one example that would fit within this directly related concept. The exercise of discretion and independent judgment, those are other key words that the Department of Labor has strictly construed as saying that you can't fulfill this exemption if, for instance, you are an employee that has a very regimented amount of discretion. So if you are using a piece of software and that software directs you to click boxes as you go through it and answer yes or no questions, that is not the type of discretion and independent judgment that the Department of Labor is looking for. Also, if you have a supervisor who very frequently overrules and looks at your discretion and independent judgment on a very consistent basis, that is another way in which you will be disqualified from fitting within this exemption. The matters of significance piece, those are more keywords, and that simply means that if you exercise discretion and independent judgment all throughout the day, but your discretion and independent judgment is very limited to decisions that are not matters of significance for your organization, that is also going to disqualify you from fitting within the exemption. So this is a very narrow exemption, and there are few folks that would likely qualify under the Department of Labor's strict interpretation as fitting within this exemption.
I would agree, and just to emphasize that point, I was involved in a DOL investigation a couple years ago where they were really focused on this particular exemption, and the DOL officer told me that even, for example, an employee who, say, drafts contracts or puts together deals, if the way they do that is to select, from a menu of potential contract terms that would be good, and it could be a fairly important deal for the company, but their discretion is basically limited to, okay, do I want to use, which particular contract form or which particular language makes sense in this particular situation. I think to most lay people, we think, well, that's a pretty significant exercise of discretion, and it's a matter of significance for the business, but the way DOL has been looking at this is narrower than that, and they basically said choosing from a menu, or if you're allowed to set the pricing for things, but you really are only working in certain parameters, those are all things DOL is going to look at in a negative way when they're looking at this exemption. They really have almost limited it to people who are creating new projects or products or putting together things that were not in your company's arsenal, to begin with. And so that's just something to consider. And when you're looking at that exemption, it's probably a good time to consult with an attorney, or an HR consultant or someone like that who's dealt with the DOL on these issues, because they've really interpreted it in a way that I don't think is consistent with most of our, kind of common sense understanding of what those terms might mean.
And that also, in talking about administrative employees, there is an exception for academic administrative personnel in higher education and educational establishments. Certain academic administrative personnel can be exempt from FLSA's minimum wage and overtime requirements if they're paid at least the entrance salary for teachers at their institution or salary level test. Minimum amount that's now raised because of the new rule. But the primary duty of this academic administrative personnel that could be exempt is performing administrative functions that are directly related to academic instruction or training in an educational establishment. So folks that might fit that bill would be department heads or academic counselors. So that's just a unique exception for educational establishments to be thinking of. Another exemption are teachers. If your primary duty is to teach, there is a exemption in that there is not a salary level or salary basis test. However, you do have to be a bona fide teacher, which means that your primary duty is teaching. So that's a pretty narrow and limited exception that we would just raise quickly for everybody to be aware of. And that leads us to the professional exemption. And to qualify for that professional exemption, the employee's primary duty must be the performance of work requiring advanced knowledge, defined as work which is predominantly intellectual in character and which includes work requiring the consistent exercise of discretion and judgment. The advanced knowledge must be in a field of science or learning, and the advanced knowledge must be customarily acquired by a prolonged course of specialized intellectual instruction. So again, we're talking about a pretty narrow exemption here as to who and what employees might actually qualify. As we mentioned, that salary test doesn't apply to teachers who work in the educational establishments. It also doesn't apply to licensed or certified doctors or lawyers. So poor us. But this is a really narrow exception, and it is particularly directed to those who are doing work that's predominantly intellectual and would require advanced knowledge in a field of science or learning. So again, very narrow exemption there. Highly compensated employees exemption is the next one on our slideshow. This rule also sets the total annual compensation requirements for highly compensated employees to $134,004, which is an increase up from the $100,000 that it used to be. So this is a increased rule change that will also take effect in December of this year. This applies to an employee who's highly compensated and whose primary duties include office or non-manual work and who customarily and regularly performs any one or more of the exempt duties of an executive, administrative, or professional employee. So it gives greater flexibility for an organization to try and find an exemption for an employee to qualify, but it does require a higher salary to get this exemption. So again, it's an increase. It used to be $100,000. In December, it will be $134,004. So, and that again, just like with the salary level test, it's a weekly basis calculation. So it must be paid at least $913 per week under the new rule. Now again, that can also include commissions, non-discretionary bonuses, and other non-discretionary compensation earned during the 52-week period. One other aspect that you should be thinking of when you're thinking of highly compensated employees, if you have someone coming in at mid-year, it can be done on a pro-rata basis. So that's something to be cognizant of if you're hiring and bringing people on in the middle of the year. So we received another question about mortgage loan originators and whether they would be considered under the outside sales exemption. So I'm going to shift back really quick to address that. This is a very specific question, so we would probably need some greater factual analysis in order to be able to respond with a concrete answer. There's lots of varying Department of Labor guidance in the mortgage arena, specifically with respect to mortgage brokers. So that is, I would say, a bit of a minefield to navigate. But possibly a mortgage loan originator could be considered outside sales. The key is how often they're doing work outside the office. And so we would also need to look at those other factors. But something to think about is whether those individuals might also fall under the highly compensated employee exemption as opposed to fitting in the outside sales category there. So switching to our next slide, non-exempt employees. So what do we actually have to do if we have employees that are on the bubble and they are not going to meet the new salary level test? And then they will be deemed non-exempt employees. Well, non-exempt employees are entitled to overtime pay for work performed in excess of 40 hours per work week. How can you all ensure compliance with this change? Well, one way that an employer can control hours worked is to use offsets within the same week. So if an employee is working 10 hours on Monday, we would want to make sure that they were working fewer hours throughout the rest of the week so that on a work week basis they weren't exceeding 40 hours, which would implicate overtime responsibilities. It's important to note, however, that an employer cannot offset one week against another. So if you have a heavy week, there's a big project, and you end up working 60 hours a week as an employee, your employer cannot tell you in the next week that you should only work 20 and hope that that will not require them to pay overtime in the week that 60 hours were worked. Now, it's important to note that when we say work week, we are not talking about a predetermined work week. So it's not a calendar, Sunday to Sunday, Monday to Monday. As the employer, you get to set what that work week is. All it has to be is a fixed and regularly recurring period of 168 hours and 7 consecutive 24-hour periods. So if it makes sense for you as an organization to have that Tuesday at noon to Tuesday at noon, there is nothing that precludes you from setting it that way. But the key is to track it so that from when that work week starts, according to your policies and practices, you're measuring to see whether your employees are working more than 40 hours in that predetermined work week. And again, just want to pay particular attention to when we say overtime being time and a half, we're talking about the regular rate of pay and the appropriate calculation of regular rate of pay. When we say that, and the FLSA has defined what regular rate means, it's all remuneration for employment except certain payments excluded by the Act itself. So you might not be thinking about certain things like bonuses when you're calculating regular rate of pay, but you need to be thinking about those bonuses because they may need to be included in your calculation of regular rate of pay so that you're ensuring that you're properly calculating overtime for those employees. You'll just note on here we also have pointed out that employers outside the public sector cannot offer comp time off in lieu of the overtime pay. So that's something to pay particular attention to.
And Ellen, we did just get one question that kind of ties in with the last point that you made about offering compensatory time off in lieu of overtime. That's something that I see more frequently with nonprofits and those type of organizations. And we got a question about church employees, particularly such as youth directors or choir directors, whether they're exempt. So the FLSA does not have an exception for nonprofits in general. So there's nothing that says just because you're a nonprofit under IRS regulations, you're not subject to the FLSA. What the FLSA does do, however, is it only has jurisdiction over entities that are involved in commerce. And so, again, this is a fact-intensive question. As a general matter, a lot of religious organizations are not going to be involved in commerce. For example, if you're strictly operating a church office, and you're just running the church and you're organizing worship services and that sort of thing, you're probably not involved in commerce. Again, you would need to look at all the factors. If your church runs a big bookstore, you might be getting into that area where the DOL is going to say, yeah, you might be operating in commerce. They will also look at particular employees. So the first question is whether your entity is covered by the FLSA. And it could be that the entity, the church, is not. They're still going to go one level farther and look at individual employees. And so I've seen DOL decisions, for example, where a church operates a greenhouse and a store. They grow vegetables and they sell them. And that helps fund church projects, that sort of thing. The DOL has said, well, church, you are not involved in commerce, but you're engaged in commercial activity as far as the operation of this greenhouse goes. And so the employees who are involved in that enterprise do fall within our jurisdiction. So again, it is factually intensive. You would need to look at the employee's day-to-day duties if you satisfied yourself that the entity itself isn't engaged in commerce. And they have said folks who regularly engage in interstate mailings, interstate communications, that sort of thing might fall under the exemption. So again, it's a pretty fact-intensive analysis, and there unfortunately isn't any kind of a general carve-out, but that would be what you'd want to look at there.
So we also received a question, which is if an employee is a highly compensated employee but is computer exempt, so meeting the classification for computer, does the new highly compensated employees or highly compensated employee exemption salary apply? So my only concern about this would be if the determination was made to categorize as highly compensated, was that because there was some uncertainty around whether they truly met the primary duties test for the computer exemption? Because if you're not paying them the new highly compensated employee salary exemption, then you would have to make sure that you're meeting the new salary level test, which it would be because $100,000 is more than the new salary level test. But your concern would be, do they really meet the primary duties test to satisfy the computer exemption? Because if that's the test you're relying on, you've got to make sure that classification is correct. So that would be my response to that question.
And that ties into another question we received. When somebody asked, well, why do we even bother with this highly compensated exemption if they have to meet the primary duties under the other exemptions? It seems like that is meaningless. The response would be, the nice thing about the highly compensated employee exemption is they don't have to meet the full duties test under the other exemptions. They do have to be engaged in what we would call, in lay terms, white-collar work. It has to be, office work. It can't be manual labor. So the DOL will look at that. And then the only other requirement is that one of their duties meets one of the duties under the other exemptions. So you're not having to look at, ticking off every box. It's basically, is it white-collar work, and are they doing one of the things on a regular basis that would satisfy one of these other exemptions? It's just a looser test. And the reason for that is DOL isn't as concerned about folks who are making what is now the 90th percentile of salaries out there. And that's why they bumped it to 134. It used to be 100. They feel comfortable that those folks are being paid a fair wage for a fair day's work. And so they're not going to scrutinize as closely whether you've met all of those duties.
So in the interest of time, we're going to go ahead and move on to the next slide, and hopefully we will get to all of the questions at the end of the presentation. We'll do our best to do that. For non-exempt employees, again, making sure that we're in compliance with this new rule change is going to require education. So if your employees have never previously been required to record their time, there's going to be a necessary aspect of education to explain to them what exactly they are required to do, how overtime works, what your work week is, and that's all going to be in the delivery of this message to your employees to prepare for this rule change. Necessarily, that's also going to require a level of education to those individual supervisors so they understand what they should be monitoring and requiring of those employees, and also so that they're mindful of hours worked, so that they can control the expenses around overtime if that's going to be implicated significantly by the patterns and practices that those particular employees have developed as being salaried employees. So it's important to note also, and this is part of the education piece, that an employer's policy or directive that no overtime can be worked without our employer approval won't prevent an employee from being entitled to overtime pay for work performed in excess of 40 hours per work week. Voluntary work counts. There's no limit on the number of hours an employer can require its employees to work in any week, which also means there's no limit on how many hours an employee might record as time that they have worked during that work week. So there's no requirement to provide a set number of hours per week, but be aware that if an employee has worked it, an employee is entitled to receive it. So under the Fair Labor Standards Act, it is not going to be a defense that you lectured the employee and instructed them not to work over 40 hours that week. Likewise, if you have provided disciplinary action and they still work overtime, not a defense. They are still entitled to those overtime payments. So that education piece is very critical, because the last thing that anyone wants is a surprise at the end of the year or a certain time period where an employee approaches the employer and announces that they've got a whole log of hours that no one anticipated, and then there has to be a calculation of overtime compensation based on the records the employee has kept. So there's certainly going to be an important education piece that goes along with this change if people are being reclassified from exempt to non-exempt. So this next slide I really enjoy because of the picture there, which aren't we all striving just to make it until payday? But the goal here is that you may be paid a salary of less than $913 per week so long as they're being paid overtime for hours worked in excess of 40. So in order to be in compliance with the new rule, this does not mean that you have to bump everyone who's on salary up to that new salary. It just means that if you are not going to bump those employees up to that salary level, you start classifying them as non-exempt, start calculating their hours worked, and start paying them any overtime that's earned. We are going to skip through quickly this next slide on record keeping, but it's in your materials, so you can go back and look at that. The important thing there is to keep it, records, all the time. So why is this important? A failure to comply comes with some significant penalties, both civil, criminal prosecution, and again, this is a slide that you can look at and review. When you're thinking about your records retention policies, be thinking about the statute of limitations. It is 2 years, 3 years for a willful violation, just to give some greater information about what it means to be willful. The employer knew or showed reckless disregard as to whether its conduct was unlawful. That is a willful violation. If an employee can demonstrate that, the statute of limitations is expanded to 3 years. So as you're thinking about your record retention policies, please be mindful of that. So I'm going to let Erin handle the hard part, which is, what do we do?
All right, so we've thrown all this information at you. You know you have until December 1, and now we want to talk about practically what are some steps you can take to make sure you're ready for this change when it goes into effect. Pre-planning is key in this situation. If you are not already doing it, you need, as soon as possible to start tracking the hours for your employees who are currently considered exempt and are below the new salary threshold. This is going to help you decide which employees you might want to bump their salary, which you want to reclassify as non-exempt so that you're going to be subject to paying overtime. It's going to help you have a good sense of how many hours these employees are actually working. If it turns out that most of your folks who aren't at that threshold are working an average of 35 hours a week, you probably don't really have a whole lot to worry about. If it turns out that a lot of them are working 55 hours a week, that's going to be cause for concern, and it's going to require you to do some analysis to figure out the business impact that that's going to have on your company and the best way to handle that. When you're tracking these hours, again, we keep emphasizing this, but it's because it's important. Make sure you're looking at the hours worked per week, not just per pay period, not per month, not per year, on a week-by-week basis. And in some businesses, I know that shifts a lot, and in particular months, it might be a lot higher. It might depend on if you have somebody who's working flex time. It might depend on if you have employees who are project-focused, versus kind of a everyday my inbox looks very similar. All of those are things to consider, but you need to be looking at how many hours they're working each week. You also need to look at your current policies to see how they're going to hold up if you end up with a lot of employees who are all of a sudden going to be considered non-exempt. In particular, your overtime policy is obviously going to be important. Hopefully you have one. You might not, and if you don't, that's something you're going to want to put in place. Ellen touched on this, but it's a good idea, even though it's not going to completely shield you, it's a good idea to proactively try to limit overtime hours by requiring pre-approval for those hours worked. Again, if an employee goes over their 40 hours and they didn't get pre-approval, that doesn't give you a green card to not pay them for the extra hours worked. You still have to do that. But what you can do is discipline the employee for not following your policy, and just kind of set a workplace culture that discourages unnecessary overtime. And having a policy that specifically spells that out can help you to do that. You want to require employees to track all time worked, which sounds pretty self-explanatory or self-evident, but you got to think about, okay, well, what does it mean to do work? Answering emails for you is working. Answering phone calls for the company is working. Going home and doing additional research on a new product is working. And so you've got to keep that in mind and make sure your policy explains to your employees what constitutes work and what needs to be tracked. Do you have adequate infrastructure right now to track time? Do you have a pension clock? A lot of times in a white-collar environment, that's probably not going to be the ideal way to do it. You can do it with something as simple as a timesheet, and there are lots, and I'm not an expert in this area, but I know from the work that I've done with a lot of employers, there are lots of software programs and things like that that you can have where employees can enter their hours, you know, either daily or weekly or whatever it is. But you want to make sure you've got that in place, and you want to make sure you have a system to ensure accuracy to the greatest amount possible. You know, you want your policy to explain to employees that they are responsible for accurately recording their time, and that inaccurate time entries may be considered fraud on the company. You want to make sure you have recourse if you find out that an employee has been inflating their hours or not recording hours that they've worked, which could come back, you know, to bite you later on. We kind of talked about this. You need to have a good definition of work in your policy. You need to require that your employees take adequate lunch breaks and explain to them that that means no working. You know, if your employees are at your office for 9 hours a day, which is pretty common now, you want to make sure they are taking an hour lunch so you don't run into an overtime issue, or that you offer half days on Fridays, you know, or some way to balance out working through lunches. And you need employees to understand that sitting at my desk and eating a sandwich while I answer emails is not a lunch break. That is time work that would have to be compensated. You also need to make sure they know to clock in for mandatory meetings. You know, if you hold a mandatory training where everybody is served pizza, they have to be there for you. That's something you have to pay them for. And again, these are a lot of issues that you probably haven't had to think about a lot with these folks that are currently considered exempt. A BYOD policy, a bring your own device policy. Do you have one of those? And this typically refers to smartphones, laptops, iPads, things like that that employees use to do work for you, but they might bring them from home. Again, does that address the use of such devices in relation to overtime? I just keep emphasizing they need to understand that work is work, no matter where you're doing it and no matter on whose device you're doing it. Flex time or work from home policies. Again, this is an area where I think there could be a big impact from this rule change. You know, a lot of employees really appreciate the ability to put in 50 hours one week and then, you know, 20 the next, depending on their home life schedule or other obligations they might have. And that's just not going to be feasible given these new requirements if the salary test is not met for those employees. And you want to make sure you're tracking hours if you have people who work from home. Again, if you have some kind of a time card system or a timesheet system, that should be workable for those employees. They just need to understand that they're subject to those requirements if they're no longer exempt. And this is what we talked about, the flex time impact that this could have on employers. Speaking of flex timers, beware the temptation to just call them independent contractors and wash your hands of it. I know a lot of employers will look at this and say, well, you know, Sally works from home. She's never in the office. Why don't we just call her an independent contractor, and then we don't have to worry about any of this? And we don't have time to go into all of the details about that. But suffice it to say that just labeling someone an independent contractor and entering into an agreement with them is not going to be enough for DOL to give a rubber stamp to that. They are going to look at what they are doing for you on a day-to-day basis. And if that hasn't changed from the time they were classified as an employee, the odds of you getting that independent contract label to stick are not very good. When it comes to rolling this out, communication is key, and I've got a clip or a scene from one of my favorite movies. So the way that you express this to your employees is really going to have an impact on morale and keeping your employees happy. You know, I don't have to tell you that a lot of employees view being classified as exempt as kind of a status symbol or you know, a mark of, you know, they've made it to this certain level. Before we started, Ellen commented that a lot of folks in your offices might not have been paid hourly since, you know, they were in high school or college. I mean, this could be a very new thing for them. So you want to be very careful when you're explaining this to your employees, the reason that they're being reclassified. You know, that the government has changed the rules and that this is something that the company has to do for compliance reasons. It has nothing to do with their the way that their job description is, the way they're looked at by the company. It's simply a result of a change in federal regulation, because you don't want these people feeling like they've been demoted. And one thing to consider in that regard is continuing to keep them as salaried employees and calculate overtime on that basis, because that way they're not all of a sudden becoming quote-unquote hourly, which for a lot of people just has some connotations associated with it where they feel like a white-collar worker shouldn't be classified that way. And that's, it's legal advice to the extent that you don't want, not legal advice, legal education, to the extent that you don't want employees to feel like they're having an adverse impact on their job, based on something you're doing. You want to make sure they understand that this is simply compliance with the government regulation. With that, I think we are just about out of time. We might have time to answer one or two questions, and I think we've gotten a few that have come in. We had one question about garnishing wages for benefits and, meeting how that interplays with the exempt amount. That really goes way beyond what we have time to address today. That actually might be a really good topic for another webinar. So we might look into that as far as, how are you calculating what the hourly rate is, what goes into that, what things are you allowed to take out without getting that counted against you. Really could be a whole another hour-long presentation. So we will put that on our list of things to address in the near future. We so appreciate all of you joining us today. We've got some links for additional information on our slide. You can also look on our website. We've got lots of great blog articles that talk about this and other employment-related issues. That also lets you know how to get in touch with us. And you will be getting a quick survey in connection with your participation in this event. And we just ask if you can take a few minutes to answer that. It really helps us make sure that we're providing the best content that we can to you in the future. And you can download this presentation off of our website. And so if you'd like to get copies of the slides, and I'm sure especially you're interested in all the fun pictures, you can do that at GableLaw.com. So thank you so much, and have a wonderful rest of your day.